Hey everyone, Kyle Walker here. If you love cars, fixing things, or just want to understand your vehicle better, you're in the right place. I share hands-on tips, smart driving advice, and straight-up car talk without the fluff. Make sure to hit that like button, subscribe to the channel, and stick around till the end. You don't want to miss what's coming up. Let's get into it.
Every motorist is obliged to monitor not only the signs, markings, and compliance with the rules, but also the situation on the road. According to statistics, the speed of vehicles, the density and nature of movement has a huge impact on traffic safety. If the driver is inattentive, even his slightest mistake can lead to extremely serious and dangerous consequences, up to injury and death of people. Taking into account all the factors, it was decided to introduce such a concept as dangerous driving. However, not everyone understands what it means, what penalties it provides, and what nuances it implies. These issues should be understood, so that in the future there are no difficulties and problems with the interpretation of the meaning of dangerous driving. What it is. For the first time, dangerous driving as an official concept was introduced back in the summer of 2016. Then such a concept or definition as dangerous driving appeared in the traffic rules. According to the Legislative Act, the term implies the repeated performance by one and the same person of actions that can provoke and entail risks of injury and death of people, as well as material damage to individuals, organizations, and state property. At the same time, the situation will be much more serious if such dangerous actions or acts in the form of offenses are committed by the driver one after another. Roughly speaking, we are talking about several traffic violations that are included in one common episode. The driver could exceed the speed limit, thus flying into the oncoming lane or sidewalk, hitting people or damaging other vehicles, flying into a building, etc. The driver could have exceeded the speed limit, thus flying into the oncoming lane or sidewalk, hitting people or damaging other vehicles, flying into the building, etc. The definition considered is a general one for such a term, but the law provides for specific offenses that may fall under the concept of dangerous driving or dangerous driving. They are separately considered in the relevant articles of the traffic rules. That is, the new term acts as a unifying concept for a number of regulations and provisions. What refers to dangerous driving? Studying the essence of dangerous driving in traffic rules, it is possible to distinguish 5 main directions and offenses that define a dangerous driving style. It is these provisions that make it possible to charge the driver with dangerous driving, issue a corresponding fine, or impose another type of punishment provided for by the traffic rules and other regulations. Here we are talking about situations when the following rules are violated and the movement of motor vehicles is considered dangerous. The driver ignores signals and calls to give way to another vehicle when there is a corresponding advantage. This offense is displayed in paragraph 8.8 of the Traffic Code. There is a rearrangement in conditions of heavy traffic, that is, dense traffic on highways. Here we turn to paragraph 9.4. The driver intentionally does not allow another vehicle to overtake himself, i.e., there is a deliberate obstruction of the maneuver. The situation is considered in paragraph 11.3. The motorist makes a sharp braking. Cases when the driver tried to avoid a possible accident are considered an exception, regulated by paragraph 10.5 of the traffic rules. The driver did not observe the distance from the vehicle ahead and violated the lateral interval with cars located on the right and left. This regulation is considered in paragraph 9.10. Dangerous driving, DD, can also be called aggressive driving, AD. In addition to these violations, OD also includes driving on sidewalks, frequent lane changes in heavy traffic, abnormal gestures, aggressive yelling, and profanity toward other drivers. The list is largely open-ended, as the specific nuances of the offense depend largely on the level of irresponsibility and imagination of the motorist himself. Conditions of recognition: there are key terms to recognize driving as extreme, aggressive, or dangerous. All concepts fit the term designation in the same way. The first condition is the commission of a minimum of 2 or more offenses that follow each other. According to traffic rules, actions will be classified as OV if the violations are related to different points of the rules, or the same point is violated, but repeatedly. At the same time, The concept of committing violations one after another is not specified, so each traffic police officer can individually decide whether the driver's action is dangerous or not. In practice, it has been proved that the movement can be recognized as dangerous even in situations where there is an impressive interval between violations. The second condition for recognizing an OV is a threat to the life or health of people, as well as to the safety of property. This condition can be considered objective and unambiguous in situations where it is actually possible to record the fact of the presence of such a threat. The fact of embodiment of the threat is manifested in the form of a traffic accident. But if there was a danger, but it did not lead to any consequences, it is problematic to fix the danger. Drunk drivers are singled out as a special case. The fact of their condition when committing a DUI may entail both administrative and criminal liability. The choice of preventive measure is directly related to specific circumstances. Namely, the driver refused to be examined. The car owner gave control to an intoxicated person. Because of the actions of a drunk driver, a person died, etc. Another special case is drug intoxication, as well as the repeated capture of a driver in a drunken state or under the influence of narcotic drugs. Administrative and criminal penalties are applied here. Read also, car battery marking, how to determine the date of issue fixation and proof. Many people had to witness egregious offenses, the perpetrator of which is simply obliged to bear the appropriate deserved punishment. Dangerous driving is precisely to such situations and belongs to such situations. Therefore, witnesses are interested in where to send the video, if it was possible to fix dangerous driving, and whether the information in the form of video clips will be considered by the police in general. After all, no one wants to have a wasted appeal and not be able to deservedly punish the perpetrator. Before deciding where to send the facts of the offense, it is necessary to record them. This is usually done by video recorders in patrol cars, but also by outdoor surveillance cameras and cameras designed for automatic recording of traffic violations. Although theoretically there is nothing complicated in fixation, in practice law enforcement agencies, that is, traffic police officers, recognize the fact of the complexity of collecting evidence. The lack of necessary equipment on many special vehicles is to blame. Also, on-street cameras do not always manage to catch a violator because of the narrow angle of view. The only question is whether a citizen will want to deal with such issues. If it concerns him personally or close people, then a person will definitely collect dirt on the violator so that he is punished. Filing a complaint. When a situation arises where a citizen has recorded the fact of a driver's offense about his dangerous driving, some want to report to the appropriate authorities. Depending on the specific situation, the witness who provided evidence may be called to the office to clarify the information, although sometimes all additional questions are solved in the telephone mode. If you decide to send a complaint with evidence through the official website of the traffic police, then here you will need to additionally fill out a special form. In the case of a written application, it is allowed to fill it out in a free form. At the same time, it is extremely important that the application contains certain information, the date of the incident, time, information about the violator, license plate number, make and model of the car, description of the situation related to the violation of traffic rules, description of the article under which the punishment is provided. After the application is accepted, it will be considered and the offender will be dealt with. Whether or not a person will be held liable for dangerous driving depends on a number of factors and the final decision that may be made in court. But you should not delay in complaining about dangerous driving if you have actually recorded such a fact and consider it fair to punish the driver for his actions. Articles and fines. Since mainly for OV provides for administrative responsibility, here it is necessary to start from the CAORF. That is, we are talking about the Code of Administrative Offenses of the Russian Federation. In the case of such an offense as dangerous driving, the punishment is regulated by Article 12.38. It is she who is the main regulatory document for determining the measure of punishment in respect of drivers who violated the requirements of traffic rules and fell under the definition of extreme driving. The amount of the fine depends on the specific article of the CAO under which a person has been prosecuted and accused of aggressive driving. Here we rely on Articles 12, 14, and 12, 15. They spell out the following provisions. If the driver did not give way to another motorist who had priority, the the punishment provides. For a warning or a fine of 500 rubles, if a driver cuts someone off, brakes sharply, or rearranges his or her driving, then he or she will have to pay 5,000 rubles. Whether this is enough to punish dangerous driving can be argued endlessly. Those who are accused consider this amount overstated and unreasonable. Those who have suffered from the action of daredevils, however, demand tougher preventive measures. Since January 2018, a new law has been in force, according to which drivers are punished for dangerous driving with fines of 5,000 rubles. At the same time, proposals that provide for an even greater increase in fines for dangerous driving are now being actively considered. In addition, drivers may be deprived of their license, and other measures may be applied. At the same time, violators naturally begin to be interested in the question of possible avoidance of fines for a dangerous offense. This is quite an expected question. After all, if we take into account the current fines and the fact that dangerous driving may soon be punished even more severely, then any opportunities to avoid paying such a sum become extremely relevant and in demand. Let's be objective. The best way would be to exclude the very fact of dangerous driving. That is, the driver must comply with traffic rules and not make maneuvers that contradict the law and traffic rules. How to avoid paying a fine? There are several options under which you can try to avoid punishment if you are prosecuted for aggressive or dangerous driving. Under the law, the penalty is not applied if the offense was committed by a person with a disability. This includes drivers with the first or second group of disability. The offender is a woman in a position, i.e., pregnant, as well as a woman who has a minor child. The offender is a citizen who has been called to duty or is a member of the armed forces. The offender has a special rank. This includes employees of internal affairs bodies, as well as representatives of the penal system. The offender is under 18 years of age. That is, in fact, he is a minor. Read also, safety of the car. How does the slip prevention work? If citizens in this category have committed an offense that provides liability under the article on dangerous driving in a harsher form than a fine, they can achieve a reduction in punishment. For example, an arrest can be replaced by paying a fine, but then the amount of the fine will exceed the standard statutory amount of 5,000 rubles. Now what concerns ordinary motorists who do not have any privileges? They should understand that the fine for DUI will be issued not by the inspector who stopped you, but by the head of the traffic police, on the basis of a prepared report. In such a situation, the only way to prove innocence is to try to convince the inspector that the driver did all his actions for a single purpose, namely, to prevent a possible accident. If the driver is deeply convinced of his rightness and is ready to defend his position to the end, it makes sense to turn to lawyers. They will help to collect evidence, as well as to challenge the decision on punishment. Is it possible to get a discount of 50% when the fine was still issued and the driver is obliged to pay it? Even here it is worth thinking about opportunities to save money. Do not forget about Article 32.2 of the CAO, which regulates the receipt of a 50% discount when paying fines. With regard to Article 12.38, there are no exceptions. This only means that even in the case of a charge under the article on dangerous driving, the offender has the opportunity to pay only half of the amount specified in the ruling. To get this discount, you just need to comply with the deadlines. The fine must be paid no later than 20 days after the decision was issued and before the fine is entered into the database of the traffic police. Why such a term was introduced, and what are its pitfalls? It is difficult to unambiguously name the reasons for the introduction of the term of dangerous driving. Based on available information, such a decision is associated with the need to toughen the penalty for several offenses committed simultaneously. Paying for each offense separately provides for a lower penalty in terms of the amount of fines, rather than a single ruling under the article on aggressive or extreme driving. No one is going to remove the concept of dangerous driving in 2018. A different trend is observed, according to which for the consecutive commission of several offenses can toughen the punishment, apply more serious fines, and also bring to responsibility not only administrative, but also criminal. However, criminal articles are used only in situations when dangerous driving has led to relevant consequences in the form of injury or death of a person, as well as damage to property. Despite all the objective positive aspects of the new concept in traffic rules and the CEO, there are still several pitfalls of OM. They were initially feared when it came to the introduction of this term. And this concerns the following points. Selectivity of inspection. Motorists are sure that only ordinary people and citizens with a small income and the corresponding status are subject to such fines, while the owners of elite cars are not touched at all or are penalized by separate articles. And this is a much smaller fine than for OV. Therefore, it is necessary to introduce a legal instrument that would allow, without any exceptions, to fine and punish all those who fall under the scope of the law on dangerous driving. Fraud on the part of inspectors. The mechanism for determining the danger of driving is very conditional, in many respects does not have clear criteria and definitions. This provokes conflict situations and allows inspectors to abuse their position. Thus, there is a risk of increasing bribery and imposing fines without objective evidence of the driver's guilt. Inaccuracies in the definition. Dangerous driving is defined as the repetition of one offense multiple times or the commission of several different offenses in a row. At the same time, there is no clear wording as to what time is meant here and how big the interval between offenses can be. In order not to find out unnecessary relations with the inspector, not to be fined, and to avoid trying to become a victim of any fraud. And fraud, the best solution is to comply with all the rules. The driver needs to drive calmly, take into account road markings, respond to road signs, do not create obstacles for other road users, and just be a law-abiding citizen. Then there will be no question of dangerous driving in relation to you. It is extremely useful to have a video recorder for such cases. With its help, you can confirm the fact that your maneuver was caused by a dangerous situation on the road, and all your rearrangements, sharp braking, and other moments, which are referred to in the law on aggressive driving, were aimed purely at trying to prevent an accident and avoid even more serious consequences. In conclusion, understanding the nuances of dangerous driving is crucial for every driver on the road. By recognizing the common behaviors that lead to accidents, such as speeding, distracted driving, and driving under the influence, we can take proactive steps to ensure our safety and the safety of others. Remember, being a responsible driver not only protects you, but also contributes to a safer community. Stay alert, follow traffic laws, and always prioritize safety behind the wheel. Thank you for watching, and drive safely.